Okay, good evening to all our distinguished participants joining us from different parts of India and abroad. On behalf of the Center for Development of Intellectual Property and Research, our esteemed collaborators, and the Symposium Secretariat, I extend a warm welcome to all the participants joining the second South Asian Symposium on Cybersecurity and Digital Rights 2026 under the third South Asian Intellectual Property Summit. We are delighted to host scholars, policymakers, legal professionals, cybersecurity experts, researchers, technology innovators, civil society representatives, and students from all across the globe. This symposium is going to come up with the various research reports and also some of the international volume publications. We'll be starting with the technical session now, and at the beginning, there are certain guidelines to be followed by all the participants. Overall technical session timing for every participants is 6 minutes, out of which 5 minutes will be for presentation and 1 minute is kept for question and answer session. So participants, kindly stick to your timings. Regarding the remaining timing, it would be notified in the chat box, so keep your eye on the chat box. So starting with the first participant, I call Aditi Jaiswal.
Good afternoon, sir. I was told that I'm supposed to join this after Suman
Aditi
Mahanti.
Jaiswal, you are not
Should
audible.
Can you hear me now, sir? Hello?
Yes, you are audible. You can start with your presentation.
Okay. Is my presentation visible to you?
Yes, it's visible and audible. You can start.
Hello? Okay, thank you so much. So, I am Aditi Jaiswal. I'm presenting my research paper on surveillance, advertising, and free consent. I'm analyzing the data sharing by big tech under India's data protection regime. So, my paper examines whether the data sharing by the big tech constitutes free consent under the India's data protection law or not. So for that, I'll be referencing the WhatsApp privacy policy case before the Supreme Court. So Supreme Court made a observation in this that this privacy policy is a decent way of committing theft, and it has acknowledged that personal data has become a commodity which is being used by big techs to exploit the consumers and serve them targeted advertisement by doing a behavioral profiling of them and share it with the advertisers. So that leads us to the question that is the consumer really the user or the advertisers? Because the big tech's revenue model consists of using advertisement is the source of revenue. So consumers basically becomes a data supplier in this regard. So I will be analyzing the surveillance advertising. So by surveillance advertising, I mean that it's a revenue model for the big tech where they use the behavioral tracking and third party data sharing with the use of cookie and cross device and cross site tracking to build a detailed user profile. And therein, there is no informed consent of the user because, as Supreme Court remarked, that for an ordinary users, the technical and complex privacy policy is not used to a consumer do not understand to what an extent they are consenting. They just want to use the services because this case arose from the fact that in 2021 WhatsApp privacy policy mandated users to accept the terms and conditions so as to use the services further. CCI took a sumo to cognizance of the same and said that this practice is anti-competitive and it had a 5-year ban on sharing data for the advertising purpose with the Meta and its subsidiaries. So my point is that this case is before the Supreme Court that there is no informed consent because users are not understanding to what an extent their data is being shared. For example, earlier WhatsApp said that there is no advertisements in the WhatsApp services. However, it has introduced another advertisement in its channels wherein it says that although your sharing of the data with the Meta subsidiary is optional, but if you see it, accept all of the data sharing arrangement is rather easy than choosing to opt out of it. So the point is, if a user accept to link its account to the account center of the Meta ecosystem, then consumer basically don't have a choice, or it's not an informed consent according to the data protection principles. Because data protection principles talk about purpose limitation, that if there is an contractual arrangement before a data fiduciary and a user, then the consent for the processing depends on the users being able to use the services. But if, am I audible, sir? Hello? Because if the users is using the services and the contractual agreement mandate that you can use the services beyond only if you accept only if you accept that data sharing arrangement with the third party, because that is beyond the scope of, for example, if I want to use WhatsApp for the communication services, why do I need to share my data with a third party where I will be targeted advertisement, be it personalized advertisement that I may not need. And in the big tech ad tech ecosystem, what happens is Facebook's not just acts as a place where I can use WhatsApp privacy services, but it also acts like an ad space where users can see targeted advertisements. So when I say about consumer here becomes advertisers, because these big techs actual consumers according to their revenue model are advertisers, because they provides an ad space for the advertisers to post their advertisement to the users. So in the whole scenario, there is no informed consent as according to the data protection principles in section 6. And the ongoing WhatsApp privacy policy case is testament to that. So when I deal with the consent fatigue that is indirectly mentioned in this present ongoing case before Supreme Court, the consent fatigue is basically, can consent be truly considered informed when it is obtained by repeated exposure to lengthy, technical, complex privacy notice that most users are unlikely to read or fully understand? Because if users do not understand what they are agreeing to, what happens to their right to informational privacy? So the point is that because there is so much process involved in opting out, there is a growing cynicism before the consumers that provide there is no privacy as such. And there is actually empirical study by the Carnegie Mellon University that says that consent in surveillance advertising is just a mere formality, and it's largely synthetic, that there is no meaningful exercise of the consent. So now that leads to my actual structural failure of consent that I've discussed in this paper is first, knowledge asymmetry. That big tech knows far more about users than users know about what data they are sharing with the big tech. Seconds, as seen in the WhatsApp privacy policy case before the CCI, that big tech continued resistance to the regulatory oversight. It prolonged litigation saying that our point
Okay,
is
participant, you can move ahead to the conclusions and your finding part. How
yes,
to
sir.
resolve. You can move ahead to your findings.
So I can hear you clearly.
You can
Hello?
move ahead to your findings.
Hello?
You can move ahead to your findings, recommendations, and findings.
Sir, I can't hear you. Hello?
Move to findings. Am I audible to you? Move to findings. Move to your recommendations.
Hello?
You might be facing some technical issue. Move to findings and recommendations.
Hello?
Move to findings.
Okay, sir. Okay, sir. I'll move to the finding. Uh, So the conclusion was that India's DPDP Act is very necessary, but it is at present the notice and consent model alone not sufficient to govern advertising, surveillance advertising model, because now consent has just become a mere formality. The whole premise of information as self-determination is proven unrealistic. The traditional notice and consent framework struggles to provide effective privacy protection. However, there were provisions in 2019 and 2022 bill that effectively could have handled this. For example, the Section 7 subsection 8 of 2022 bill and Section 11 subclause 4 of 2019 bill prevented service provider from making such an access to a service conditional upon consent to processing. However, this is not there in the present act. So for that, we need to strengthen the transparency norms, that the disclosure that have very technical and complex language needs to be mandated in a plain language, and there need to be a real time assessment of the flow visibility for the users. Second, that there was earlier a recommendation on the right to data portability and right to be forgotten in the earlier bill, which is omitted from the DPDP Act, which was very necessary for giving the consent or the right to informational privacy for the users. And second, the third party transfers should require an explicit, granular, purpose specific consent for each data sharing, and not a blanket bundled consent as we have seen in the WhatsApp privacy policy case. And second is data protection needs technical expertise, because we are talking about digital advertising, which is being handled by the big techs. So for that, we need to draw from the case of Bundes Scotland that was in European Union, that could guide India in better understanding how this surveillance advertising framework work with respect to advertisings.
Okay, participants, am I audible to you now?
Yes, sir.
Participant?
Hello?
Okay. Okay. So, coming to my first question, specifically, you talked about some of the forced consent mechanism, if I am not wrong. Like, for example, there are a number of websites where they
Yes, sir.
had come up with the consent mechanism, like caches and the crawlers, where the users are asked to first like scroll down whole like their what to say, their agreement, consent agreement, and then only it can be agreed upon. Otherwise you cannot click agree now after without scrolling whole agreement. So in those mechanisms are basically like in a legal term, those are termed as a forced consent mechanism, but the users are forced to scroll down and they pretend to submit such kind of syntax into the system that the users has read everything. So my question is like with these aspects, whether European Union has some rules or regulations, or even US is having some rules or regulations. Have you researched upon it? Yes, participant. Have you researched upon it? Okay, like participant is facing some
Out.
severe technical issue.
Hello?
Okay, okay. All right. We'll be moving ahead with the next participant. You can
क्या हो
just walk in this
गया?
aspect whenever you'll be looking up into the
Hello?
recordings of this session. You can walk in this aspect. Thank you. We can move ahead with the next participant. Now, for the next participant, we have Aranya Nath and Gautami Chakrabarti. Okay. Yes.
Please allow my co-author to be joined because she will present.
Okay. Yes. Yeah. You guys can start. Participants, you are not audible. You are not audible. No, you are
Gautami,
not.
please unmute.
Okay, your co-author left this session.
Okay, let me. She's
She
joining.
is.
She's
She
joining.
has joined. She has joined, but we cannot see your slides. So all the participants kindly keep note of this technical issue and check your network connectivity. Yes, Gautami, you can continue with your presentation. But still you are not audible. No, Mr. Nath, will you continue?
Um, Actually, let me check. Okay. I need to continue then because she is facing some technical issues, basically.
Okay.
So let me. Actually, I am continuing the presentation. Okay. So my topic is blockchain technology. One second. Blockchain technology as a technological tool against OTT piracy. Basically, my topic lies on that. As my co-author is unable to present, so I'm presenting the slides. So I'm sharing the, so I'm presenting
Okay,
over here.
slides is already visible. Slides is already
So
visible. You can
slide is
like,
visible, but I don't know whether she will be able to change the slide or not. But so I'm just presenting on my own way. The evolution of OTT platforms. As we know that the OTT platforms has been evolved since from 1990, and now today we are using the various OTT platforms like Disney, Hotstar, Amazon Primes. Then also we are observing there are various live shows are there where the performers are performing in the live television in the live podcast websites. Now the main problem that arises over here is the what is the nature of the OTT piracy? Because nowadays middleman attack is the most common attack in the OTT piracy. Because the performers are performing and some of their performance has been stream ripped by the third party user by third party pirates and upload in the user upload platforms, which creates a significant economic loss and for the performers who are performing for their own copyright protections, because copyright is the creativity which protects the artistic aspects, but their aspects are getting hampered because of the economic and social impact, because the revenue loss, consumer risk, risk arises due to the illegal streaming, and revenue loss due to the harm of the sales and the transmission of the video through unauthorized user upload platforms, and skillful innovations, because the innovations are good but the protection becomes very much linear with respect to that. So as a result, the performers are getting hampered because of that. What are the traditional enforcement mechanisms were there? In Indian legal framework, we have Copyright Act, which got amended in 2012, where the DRM facilities are there, which defines the infringement and intermediary duties are also there. IT Act, the Sector 79 is also there for the safe harbor provisions. But the traditional method falls short in DRM and watermarking, which is easily circumvented, and therefore it raises a significant questions about the fair use. And second, the takedown notices, which where the content reappears quickly on the decentralized and on mirror sites. And thirdly, the VPN and proxy servers, which bypass the geographical restrictions in the website location. And lastly, the intermediary liability, which highlighted the difficulty of policing the user-generated content in the platforms. Therefore, the blockchain act as a tool for protection. How it will, because it acts as a transparent mechanisms for verifiable, where maintaining data security rights holder can be tracked, and content distribution across the jurisdiction will be full accountable, and there should be no sort of any kind of dispute will be arises based upon the consent of the performance. That is the concept of blockchain. But blockchain anti-piracy mechanisms and the real-world application. Blockchain acts on the digital fingerprinting, tokenizations, music industry leadership like the audience and the Ujo Music have pioneered the blockchain for right management, giving artists the greater control over profits, media chain attempts, and also decentralized and streaming platforms. Where the emerging platforms aims to connect the creators directly with the consumers, which were bypass the intermediaries. Blockchain copyright registries capture the ownership also and license the data also. But the main reasons, the what where the myth arises is that blockchain stops all piracy and replaces DRM and immune to circumvent the issues. But in
Okay,
reality,
participant,
it
move
is.
to the recommendation.
Yes, sir. I'm just going the last slide only. But it cannot prevent the copying, the facing the scalability issues and regulatory uncertainty and piracy adapts. So therefore, as a recommendations, we should adapt. We should take down the main issue that how to protect all these things. To protect all these things, we should have the law must be adapted to decentralize the infrastructure, address the ownership and liability and the judicial issues under the Copyright Act and also in the IT Act. And the public should be aware and public should be educated about the copyright and its ethical uses. And also the public-private partnerships can drive effective and anti-piracy efforts. And also the combined blockchain and AI monitoring and traditional DRM for open accountable enforcement process, which is known as a hybrid enforcement, will be there, will which will help it to protect the piracy mechanisms. Thank you so much.
Okay, participant, don't you think so? Like protecting the piracy in the OTT is much of a technical aspect rather than legal. Because if the technology becomes that strong that a piracy is like no one can do, then automatically problem would be solved. Specifically, if you had to think, Netflix has developed such kind of technology into that, which is one of the patent application is submitted upon it, that they are even a mirror or screen mirroring is not possible in order to even take those videos from the Netflix. So like technology is developing, then why there is be requirement of such laws and regulations which you had referred into?
Because the technology is developed, that is okay, but my point was over here and that focusing only on the part on the website on the music or the movies. I'm also focusing about the live performance which is performing in those apps like the Netflix or Hotstar, where the live performance are taking place, where the live shows are there. In live shows, they are not able to protect the same. Like Geo Hotstar, they are not able to protect the same because in live shows, the stream ripping option is very much there, which is done by the third party unauthorized user unauthorized user upload platforms, UUP's upload platforms. So therefore, for that we need to check the copyright protections.
Okay, then like I think that your aspect of your paper has to be changed to the live, specifically live streaming. It is not a
I have
OTT.
already mentioned that the streaming platforms. It's already mentioned in the article that we are working on the streaming platforms.
See, your topic states blockchain as a technological tool against OTT piracy, but nowhere in the
I
topic it
understand.
is.
Okay, I will make the topic
So you
more
have, yes,
informative. No
yes,
issues.
yes. You have to reframe the topic. All right. Thank you
Okay,
for
I
your
will
presentation.
because if that topic is okay, I need to read for the topic. That is okay. That is fine, sir.
So now moving ahead with the next participant would be having Suman Mahanti and Aranyanath. Okay, you are
Uh,
again one of the participant.
See, I will be presenting the paper.
Okay. Okay, your
My
co-author is
PPT is
not present.
no, my co-author is not present, so I will present this paper.
All right.
So it is about the deepfake technology in India. evaluating the legal framework for misinformation and image rights. Okay. So basically, what is deepfake? It is all about the AI generated audio, video, or images that show the real persons saying or doing something which that actually doesn't happen. It is about the fake videos that generated through AI mode. But what are the harmful aspects of that is that key non-consensual pornography videos, the political disinformation, financial fraud, and video chatting. Also, it takes place through the AI voices can create a lot of frauds. Nowadays, in many villages, this such kind of frauds takes place through these deepfakes. So why this matter for India? Why it is so much burning? Because the first and foremost is the political fake videos, which takes place during the election procedures also, and also the financial aspects. If we look, then by through KBC and all, the financial frauds can take place with the people who are not so much educated, or the people who are living in the villages or in the towns, or mostly the people like from the elder ages, through financial frauds and asking the OTPs and all through this, which create the which is becoming the serious issues about about the concept of trust and ownership. So that is the main problem that why it is matter is for India. What is the main problem? The main research problem is that there is no image or personality rights statutes. No single law stops the AI from copying your face or voice or likeness without consent. And the second is there is no such platform accountability is there, and therefore the freedom of speech and innovations, there should be a balance that we can't say whatever we are free to speak as per article 19 is concerned. So that we need to take it care of. What objectives what are the objectives? It assesses the whether the India's existing laws can control the defect misinformations, because the main issue that over here is that the consent is the main problem, which the effectiveness in the misinformations becomes a significant question that we need to understand. And also we need to know the laws of European and US and China on the regulatory models, and we need to understand where our country is lagging behind with respect to that. Methodology, we have applied doctrinal methodology where we have compared with the countries like European Union, US, and China, and
Okay,
also we talks
you
about the
can straightly move
legislations
to the findings. You can straightly move to the
findings.
findings and recommendations. Yeah.
Okay, okay, recommendations. Okay. So, personality rights built by courts, but there is no statutes. And for that, we have three cases: the DM Entertainment cases versus a Baby Gift House, where the Daler Mehdi's uh, logo and his likeness was there, which infringed the publicity rights also. The Titan cases versus where the property rights in the name has been evolved, and therefore, the recommend what I'm trying to recommend over here is the dedicated defect laws must be there, and statutory image or personality rights must be codified, and there should be a platform accountability, and the people should be literate with respect to that, for their own safety with respect to the defect protection. Thank you so much.
Okay, Mr. Nath, there are two suggestions from my end. Like specifically, the paper should looked into those aspects. First, when we looked into this kind of vital issues like deepfake and the other platform-related regulations, where chance of misuse are present, in those cases, firstly you have to come up with the mandatory KYC thing, like know your customer thing by the platform, where the platform identifies these are the users and who would be misusing or who would be allotted to use those particular softwares or the system and the technology. So your first thing is how you can suggest or how the mandatory KYC can come and help in those regulating system regulating for their platforms. The
Sure,
second
sir.
aspect is, whenever you tell that to come up with a protective mechanism for the deepfake. We cannot blindly just make a protective mechanisms or regulations that this system will automatically detect. It's not possible. In a single minute, thousands of deepfakes are being generated, so it is not possible by the government or any ministries to regulate those. So how you can regulate those? There are consolidated research documentaries or the research data which is available. I will ask you to look into some of the OECD repositories you will find, or like you can even look into the AI data sets of deepfake, which would be easily available in the websites. Thank you
Sure.
for your
Thank you so
presentation.
much.
Yeah, now we'll be moving ahead with the next participants, Dr. Mandar Chaudhary.
Yeah. Good evening, all. I hope I'm visible and audible.
Yes, but your
Can you
slides are
see
not
my
visible.
PPT? Okay,
No,
it's
it's
saying processing. So,
the PPT processing takes time, so all the participants can keep your PPT loaded. It takes time.
okay. So while the PPT is processing, shall I move ahead with the presentation
Okay, you
or?
can start. Yes, you can start. Your PPT is
Okay.
visible too.
Okay, PPT is visible. Okay. So, good evening, one and all. Myself, Mandar Saudari, and I will be presenting the topic which is manufactured consensus, algorithmic amplification, partitional television, and erosion of demographic deliberation in India, India's digital sphere. The point of assertion is basically we are our liberal democracy is basically fracturing, and we are either moving to far right or far left. That is not pertinent to India, but that could be seen in the USA, UK, and Germany, especially in the matured democracies. So those are the for flow of my introduction. So I'll be quickly telling you what is basically the fracturing of mature democracies means. We are resorting to the populistic means. Populistic means could be a large bind. Populistic means could be extreme right. Populistic means could be extreme left. Populistic can be anywhere. So, because of that, because of fractured deliberative democracies, we could see the right wing or left wing populism as we see. Those are the literature reviews, and I will be quickly moving with the data analysis and the findings. Basically, the methodology as follows. This is the research universe, that is the mature developed democracies: USA, UK, Germany, India, and through the data analysis I have found some interesting results. Basically what I've done is basically I've done natural language processing in the Donald Trump speech. I've done in many European leader speeches, but here pertinent to this paper I've taken the Donald Trump speech. Here I could identify very interesting analogies. Whenever a Trump has spoken for a larger duration of time, and whenever Trump has spoken for a lesser duration of time, the point of assertion when the attack on the Capitol Hill or during the COVID, where the country needs to be addressed, at that time the leaders has spoken in very short span of time. Then I would like to highlight the role of media, how the partisanal media can play a role. Here I have identified the most TRP'd news channel, which is the Republic TV, and I have analyzed the news debates, their hashtags, and their topics of the presentation. In general, in the 5 years, basically the core topics such as healthcare, education, COVID, wildlife science and technology have only garnered only 6% of the prime time debates, but rest of the debates majorly of anti-opposition, party politics, CA, and that's how things are. That is not issue of the single media, but all the majority media could see those side of prime debates. Even when we analyze the hashtags in the digital mediums, especially in the Twitter, or earlier used to be called X or Twitter, basically the same hashtags which is run on the TV news channel are run on the digital platforms. The majority hashtags are no Karna politics, park of Vadras. That's how. Very rarely you will see the hashtags which is run from the traditional digital media through the digital media could be talking basically on the healthcare, education, scientific development pertinently. So point of assertion is this digital narrative, this traditional narratives linked with the digital narratives, is causing us to move either in the far or extremist ideological direction. And the social media is creating the amplified silos. Amplified silos meaning basically whatever my liking or whatever, if I'm on the periphery of something, which will take me to extreme of the either alternatives. I would like to take a case study of the Brexit, and I would like to highlight in better manner during the Brexit time 2016, the whatever the hashtags which is popular, that can, if you could see analysis through this, the majority of the hashtags are either Brexit, you people wish to move out of Brexit, or people wish to remain in the Brexit. There are very less hashtags. There are very less hashtags which is focusing on basically European Union reform, which is very few hashtags which is focusing on basically employment generation, which is very few hashtags which is addressing the core issues pertinent to the majority of the people. So, so the point of assertion is basically it starts with leader try to move your sentiments to the either rights, then the traditional media, and then basically through the digital media, through the hashtag, through the Twitter, or through the Instagram. And now if we ask the people were they happy with the Brexit, majority of the people, including the urban areas or including the rural areas, generally tend to dissatisfied with the present scenario. And this intensity has been amplified with the advent of social media, TV, traditional media, and traditional media linked to the digital spaces. And that I would like to pose something which is known as contractual disillusionment syndrome. Quickly, within a minute, I'll just highlight what is contractual disillusionment syndrome. In the traditional harmonious social contract, citizen will obey the duties, and the state, which is government, will protect my right. But in the present 21st century, in majority of four countries, I have researched, basically citizens are becoming extremely nationalistic. Citizens are becoming extremely obeying, but at the same time, government is not able to protect the rights, not able to protect the digital rights, not able to protect the multiple rights. And even the same point of time, citizens are actually becoming extremely nationalistic, extremely obedient to the state, to the structure, to the basically entire system. That phenomena is increasing, and that I would like to coin as contractual disillusionment syndrome. People are disillusioned to the social contract and yet tend to obey the structure. So that is the structure, which is thing. And thank you so much. I'm open to all the questions and all the.
Okay, like for your paper, one of the major concern, like what I felt is, nowadays government and the opposition, whatever in all the democracies currently in the world, they are coming up with the front-facing social media, like trends and the front-facing social media tactics to even to blanket up any of the topics or pertaining topics to those topics which are not in favor of their interest. So
Correct.
let's say a very recent trend in India, what is was Cockroach Janta Party, which every one
Correct.
of us saw. Yes. So, what according to you, like, how a people can perceive those trend? Because what is the general people's perceivance as of us and you, or as a normal common human being? We go for the like a trending nature. We go for the followers, or we go for the number of posts, as you already mentioned that the number of hashtags the post is having, those kind of thing the people generalize that there are mass supporters into it. And but nextly, whenever we assess those platforms, that just few days back, even number of influencers across the subcontinent, they came and assessed the Cockroach Janta Party platforms, that how many followers they are having of Indian origin in the other countries, and how many are of bot followers. So when we look into this assessment, there are number of chances that the followers who were bot followers and the contributions from the other country can easily be assessed, and the narrative who is supporting it, who is not supporting it, can easily be framed. So how a government governance should look into it, and as a policymaker, how what should be the recommended policy to come up with a well structured manner for this?
Absolutely correct. I'd like to answer in a very brief. before understanding what it is, we need to understand why it is. Basically the same has been happened in Nepal, but with the maximum proportion. The Gen Z, which is start with the social media movement, which eventually led to the upthrowing the basically the present income present position. The basically I would like to identify the model which is suggested by the Amartya Sen, which is the capability approach. If our education is well, if our youth is well educated, well skilled, and basically healthcare is taken care, then then the movement of the periphery will not take into center stage, and we need to address the core issues of employment, health, education, and skilling. That is the core objective, and that should be the center stage of in any deliberation, whether in TV, this conference, or in the hashtags basically. So the deliberation should be more matured. The beauty of a democracy should be harnessed, and we have a parampara of Vasudhaiva Kutumbakam. We have a parampara of matured deliberative democracy. That should take on center stage. That center stage can be TV. That center stage can be a digital space. That's what I feel.
Okay, adding upon to your research, like for a better refinement and to structure out your policy
Yes.
recommendations. So there is one of the report by our Ministry of Information Technology, Government of India. If you looked into, I don't recall the year the report was passed. At that time, it was I think of 2018 and 2019, where there was a transition of IT acts and the IT rules at that point of time. So the report says that the government has to mandate the KYC for the social media platforms in order to crack up the fake accounts or the bot
Correct.
accounts.
Huh.
So that it would be easily traceable that who is supporting, like let's say the trends. Now we don't know whether the trend is being promoted by the bot accounts. We don't know because there is no such mechanism, no such mandate that the ID which is being created, it's being supported with and it's not being supported with any of the government KYCs, right? So I will ask you to keep on this kind of research policy recommendations, whether if we included those things in coming future, whether it would give a good democratic governance setup or there would be some backlash towards it. I will ask like you to research upon this aspect also.
Certainly, certainly, sir. Thank you so
Okay,
much.
thank you for your
Certainly.
presentation.
Thank you so much.
Okay, next we have Kanchan Taksale.
Hello, good afternoon, sir. Can you see my screen?
Yeah, I can, but you were not visible.
Actually, I'm having some network issue as I'm at my native place, so it will be great if I can only present my slides.
Okay, but presenting with the camera is mandate for this session. All right, like there would be some negative marking for this. All right, you can start.
Okay, sir, no issues. Yeah. So good afternoon. So basically, like when we walk through shopping mall or railway station or airport, hundreds of CCTV cameras are watching the environment to ensure the public safety. But the important question here is, can we improve the security without sacrificing the privacy, freedom, and civil liberties? Based on this question, my research is balancing security and civil liberties, a hybrid AI framework for real-time surveillance system, where basically I have proposed a novel framework called HSSD Net, which is Hybrid Selective Hierarchical Detection Network. These are my research objectives. So basically, a review of existing literature reveals a critical gap. While significant advances have been made in AI based on surveillance for threat detection, far less attention has been given to the proportionality, privacy, and civil liberties. Many of the systems which exist prioritize the detection performance, yet high false positive rates can lead to unnecessary suspension and monitoring of innocent individuals. And this raises the important question, like how can the surveillance system enhance the public safety while also remaining consistent with the democratic values and human rights? So by this motivation and the challenges that I have found in the literature review, I have proposed HSHD net, that is Hybrid Selective Hierarchical Detection Network. And the gap is that most surveillance research focuses on deduction accuracy, whereas my work incorporates civil liberties, proportionality, human rights considerations into the design of the surveillance framework itself. So these are the four objectives I'll be talking about throughout my presentation. That is the development of HSSD net, then reducing the false positives. Third is to preserve the privacy and civil liberties, and
Okay,
finally fourth one.
participant, you can just go to your research question and come up with the solutions and find it.
Okay. Talking about my first objective, that is development of HSSD net surveillance framework. This is how I have developed a framework. That is, the process basically begins with the live CCTV video stream. It is a first stage to use YOLO model for rapid real-time detection of people and activities. And instead of immediately labeling an activity as suspicious, the model introduces a selective verification stage, just like a second opinion. In the next part, the system performs temporal analysis, where I have used the deep learning models like GRU, LSTM, Transformer, and basically this has allowed the framework to understand behavior over the time rather than making decisions from a single frame. And finally, I have used the hybrid decision module, and I have categorized the activities into three sections: normal, suspicious, and uncertain. Moving to the second objective is to reduce the false positives in the real-time threat detection. Um, like the false positive occurs when normal activity is incorrectly flagged as suspicious. So here at the first, the selective verification gate rechecks the suspicious detections before further processing. Secondly, the temporal behavior analysis will examine behavior across multiple frames instead of relying on single image. Third is hybrid decision fusion, where it will combine the outputs of multiple AI models to improve the decision reliability. And finally, the system will introduce the uncertain category, allowing acknowledge uncertainty rather than making the potentially incorrect decisions. And this will basically can reduce to only 2 to 4 false positives, where maintaining over 90% percent of precision. Uh, Talking about my third objective, to preserve the privacy and civil liberties in AI surveillance. So basically, the first is selective verification, where only high risk detections receive additional analysis rather than subjecting everyone to intensive monitoring. Secondly, temporal context analysis. Third, introduction of the uncertain category. And through this mechanism, this HSSD net follows rights aware approach in which surveillance assists human judgment rather than replacing it. Uh, and the last objective is to improve the context aware suspicious activities. Here, the framework combines three types of information. First, special features, motion information, and temporal analysis. So, these are all basically four objectives. Based on all this, what results I have got? Uh, the temporal model has achieved the best overall balance with approximately 90% of accuracy, 91% of precision, 70% recall, and F1 score of 0.79%. And the transformer model achieved the highest precision of 94% and the highest AUC. So these are the results which I have got. By combining these results of various models, I have basically made a hybrid model, that is basically combination of the best models which we have developed. So the hybrid fusion says that it has achieved, the overall system has achieved the high precision of nearly 98% and an AUC of approximately 0.96, which basically indicates the highly reliable threat classification. Thank you.
Okay, participant, when we looked into this type of model, there is one of the major issue, like how your framework addresses this black box problem associated with deep learnings.
So right now, sir, I have not yet worked with the real-time data. I am just proposing a framework. So the data that I have collected here for this model making is just taken from various sources which are right now available, and then I have developed this framework.
Okay, but still, like you would be having a demographic informational chat that how it should be implemented, like those kind of data sets, right? Like if you are not having, you should research upon it somehow, and to also look into the black box, like how it can cater up those issues.
Yes, sir. I'll work on it.
All right, thank you for your presentation.
Thank you, sir.
Yes, now we are having next participant, Disha. We are having next participant, Disha. Yes, you are not audible and visible. Miss Disha, you are not audible and visible.
Uh, am I visible?
Yes, yes, you can start with your presentation. Your slides are visible.
Good evening, everyone. Respected members of the panel, I'm Disha Simar, and I'm presenting my paper titled Algorithmic Biases and Inclusive AI Governance in India, Regulating Representational Inequalities in the Global South. So the core question driving this study is that an automated decision making increasingly mediates the access to vital public infrastructure, healthcare, and social welfare across developing nations. So, how can we construct a legal framework that actively prevents these systems from translating historical societal prejudices into automated systematic exclusions? So to understand this urgency, we must there are three fundamental part of the problem. Global South context where deep-seated social hierarchies like gender disparities, caste hierarchies,
Your
and
slides are not moving.
pardon,
Your slides are not moving.
is it moving now? I'm in the introduction part. So the results in sampling bias where marginalized communities are underrepresented and measurement bias where flawed proxy variables are treated as objective reality. For instance, when an algorithm uses historical commercial healthcare spending as a proxy for actual medical need, it fundamentally misinterprets the poverty as an indicator of good health because improvised individuals simply cannot afford the care. So similarly, if medical AI relies on historical clinical datasets where women's data was systematically uncollected, it translates directly into clinical harm and misdiagnosis today. So this leads us into the central truth, highlighted by the Cathy O'Neill, who demonstrate that algorithmic models often intensify existing social inequities precisely because they are trained on data reflecting pre-existing societal disparities. So the central question is, how can India develop an inclusive AI governance framework capable of addressing representational inequality affecting the marginalized communities? So here the first, it analyzes the limitations of India's existing AI governance. Second, it compares the India's approach with the regulatory models adopted by the European Union and the African Union. So third, it proposes the practical reforms that could strengthen the accountability and fairness in high-risk AI systems. So when we look at the India's current regulatory framework, we find that there are there are some structural omissions. The primary issue is that India's approach completely misses the predictive inference layer, where the algorithmic bias really actually occurs. So looking closely at the three main tracks, the Digital Personal Data Protection Act of 2023, it regulates data collections, storage via consent, but it establishes absolutely no regulatory standards for fairness and data representativeness of the inclusiveness of the underrepresented communities. So meanwhile, Niti Aayog's national strategy and responsible AI framework represents AI primarily as a tool for economic growth and technological development also, but it relying entirely on voluntary ethical guidelines rather than legally enforceable remedies. And finally, the India AI mission focuses heavily on computing infrastructure and industry scaling, leaving algorithmic bias oversight completely outside its scope. So to evaluate this framework systematically, uh, We must evaluate the global approaches, specifically the contrasting of the European Union and the African Union models. The European Union has established AI Act, which operates as a strict, legally binding compliance model. It explicitly classifies the public sector and healthcare AI developments as high risk and mandates that.
Participant, you can move to the recommendations.
Uh, okay. So, to successfully move from the privacy only focus to algorithmic through algorithmic accountability, India requires three core legislative pillars. First, we must implement mandatory dataset diversity standards by amending the DPDP Act to require AI providers to mathematically prove their training data accurately represents the caste, gender, rural, and linguistic demographics. And second, we must establish enforceable algorithmic impact assessment, mandating that independent pre-development deployment evaluation to actively test AI systems for differential error rates across demographic groups. And third, we need mechanisms for demographic accountability and due process, meaning we must track outcomes for the post development deployment via intersectional analysis. For example, the system must track the specific algorithmic exclusion faced by the rural woman rather than obscuring her unique disadvantage within the aggregate statistics for women or rural population generally. So here, to bring these pillars into operation, I propose the multi-dimensional regulatory scorecard. This tool functions as a mandatory pre-deployment clearance procedure rather than just a voluntary checklist, meaning that the systems failing this metrics requires immediate remediation before the pre-deployment of those data. It evaluates high-risk AI based on six fundamental criteria. First, the data set diversity, checking the data reflects India's caste, linguistic, economically weaker sections, and informal labor realities. And second, equitable testing to see if the error rates and performance are truly equal across the demographic groups. And third, transparency, um, ensuring the reasons for automated decisions are clearly explained, and for the human oversight, requiring that human in the loop to actively prevent automation bias. And the fifth, the redress mechanisms, ensuring that affected individuals have a clear statutory right to appeal. And the sixth is public interest, verifying whether the systems prioritizes constitutional equality over the sheer processing efficiency. Thank you.
Okay, participant, have you referred one of the latest Niti Aayog's report on AI, artificial intelligence in India?
I have, but the thing is that it also supports the data collection and the it talks about the more of the ethical part also, how the economic development is. But I'm talking here about the how the underrepresented communities can be included in the data collection. Sometimes when at the university level projects are being done on this, and but they give incentives to the like 100 rupees incentives, but the data is collected only for the particular section of the society, like students will come, so the data will be biased, the algorithmic biasness will be there. And obviously AI won't show that there will be proxy variables, so synthesized data can be shown. And for example, in healthcare it's not good for the diagnostic system. For some of the section of the society it will show the right diagnosis, and for the section which is like economic weaker section it won't show the same level of fairness.
Okay,
So
all right. Thank you for your presentation.
thank you.
Okay, next we are having Dr. Sumanta Bhattacharya. Yes. Okay, due to some technical glitch, Dr. Bhattacharya has left it. She would be joining soon. So till the time, we'll be moving ahead with the next participant, Dr. Pooja and Angel Basen. Yes, Angel Basen,
Yes, I'm sharing my screen.
your screen is already shared. Dr. Bhattacharya would be moving ahead to you next. You had left, that's why you have to start with the next participant. Okay, participant, you are not visible and audible.
Just a second, sir. Is my screen visible? I've not
From
presented.
you are joined from two accounts.
I've joined from one only.
Okay, your screen is not visible.
Yes, I'll do that.
Okay, if it takes time, we'll be moving ahead Dr. Bhattacharya again, then we'll come to you. Yes. Dr. Bhattacharya, are you present here? Okay, he is also having some issue. Miss Basen,
Yes, sir.
okay, you may present your screen and like first unmute yourself and also like you are not visible.
Okay, sir. Just give me a second.
It's taking time. Would be moving ahead. Next participant, Roshmi Paul. Okay, Miss Roshmi. Yes. You are not audible and visible.
Is this like it's visible?
No, you are just audible. You are not visible.
Just a second. It will take hardly 1 second actually.
Yes. Okay. You can share your presentation.
Sure.
So all the participants keep your presentation loaded. Otherwise, time would be not provided and it would be cut from your allotted time. Miss Paul, your presentation is not visible.
Just a second. Actually, we were supposed to be up late, but the other participants delayed. That's why we are at first. So we prepare accordingly. Like we are not ready with the presentation thing, actually. Just need 1 minute for it.
Okay, Miss Basen, are you ready with your presentation?
Yes, sir.
Okay, we'll be taking you now. Go ahead with your presentation. Your screen is visible. You are not audible. You are not audible.
I'm trying to unmute myself, but I'm not able to share my screen at the same time. I can only do one thing at a time. I don't know, there's some glitch or something. I'll just do again. I'll try again.
Participants, kindly be fast. It is delaying up. Okay, yes, I think your presentation is visible to me. Okay, yes, you can start up with your presentation. Miss Basen.
But I'm not able to, share my screen and turn on my camera at the same time.
Okay, you can
Well,
start with the presentation without turning on your camera. It is delaying.
Okay,
Yeah.
sir. Good evening, respected Chair. My paper is titled Digital Biopiracy and AI Protecting Indigenous Knowledge and Rights in the Global South. Traditionally, biopiracy involved the physical extraction of biological resources and traditional knowledge from indigenous community. Today, however, the same extraction can occur through digital sequence information, biodiversity database, digitalized traditional knowledge, and AI training system. Now, to understand why this issue matters, we must first examine how biopiracy has shifted from the physical world to the digital domain. To understand this, we must recognize that biopiracy has undergone a fundamental transformation. That is, knowledge can now be copied, scrapped, translated, and trained into AI system. Traditionally, biopiracy involved the physical extraction of plants, seeds, biological materials, but now it has shifted to digitalization. Today, however, value can be extracted through digital sequence information. As a result, knowledge can be copied, aggregated, incorporated into AI systems long before any patent application is filed. The question, therefore, is not whether biopiracy still exists, but how legal systems should respond when extraction occurs through data rather than through physical resources. Now, my paper will be following three primary methodologies, that is doctrinal, comparative, and case studies. Doctrinal is the study of domestic and international norms. Comparative is the bilateral access and
You
benefit
can
sharing.
skip the methodological portion. You can skip and move ahead to the research question.
Okay, so the primary research question is how can South Asia and Global South legal framework prevents AI-enabled digital piracy while preserving legitimate research and open science? Now, the legal framework that the paper has employed is CBD and Nagoya Protocol, the WIPO Treaty 2024, COP16 and California, and India BD, the Biodiversity Act, Patents Act, and Traditional Knowledge Digital Library. Now, moving to each of them, firstly, the CBD, that is the Nagoya Protocol. It talks about the sovereignty, prior informed consent, mutually agreed terms, and benefit sharing. But there's a limitation that they are built around identifiable access transaction. Now, the WIPO Treaty, however, it answers the question of patent disclosure for genetic resources, but it has a limitation. The limitation is that a disclosure arrives late and does not itself create consent. It focuses on that the laws are not preventive in nature, they are defensive in nature. In India, the Biodiversity Act, the Patents Act, and the Traditional Knowledge Digital Library says that. Moving to the case studies, that is the lessons for the digital state, we'll be talking about the turmeric, neem, and basmati cases. Um, yes, just a second. My research finds that the existing legal framework remains highly relevant, but it is not fully equipped to address digital biopiracy. The Convention on Biological Diversity and the Nagoya Protocol it established important principles, but it lacked sovereignty. Now, the turmeric, neem, and basmati disputes demonstrated that traditional knowledge can be vulnerable when it is not adequately recognized with formal intellectual property system. In each case, protection was achieved only after significant legal challenges were undertaken. That's what I mentioned earlier. The Divya Pharmacy decision further illustrated that benefit sharing is not merely an international issue, it is also a domestic governance responsibility. Finally, the recent AI training disputes, although not biodiversity cases, revealed an emerging legal concern, increasing security. Then, these case studies lead to the central analytical claim of my paper. The real governance gap lies in what happens between the source of knowledge and the final commercial output. Now, I argue that digital piracy is not a single event, it is a chain. It begins with community knowledge, such as traditional medicine practices, seed varieties, ecological practices. Those are indigenous knowledge belonging to the indigenous communities. They have developed over generations. Once this knowledge is digitalized, it becomes a record. It is a data now. These records can be collected and combined in datasets, which may be used to train AI systems. The AI model may eventually help create a new product, a patent, a crop variety. The problem is that as knowledge moves through each stage, information about where it comes from is either not mentioned or just eliminates from it. Now, today, the law usually becomes active only at the final stage, when a patent is filed or dispute arises. The argument is that protection should be much clear, and it should begin at a much earlier state. We should ask that whether consent and benefit sharing obligations with the data throughout the entire journey only, or they begin at the early stage or at the later stage. If value is created for community knowledge, the connection between that value and the original source is lost. If the problem is that information gets lost, that data moves through its chain, then the solution is to make sure that the rights and responsibility moves with the data. The idea can be proposed through the TKDL 2.0 model, and this is the model proposed. This is something that can address this challenge. It is a right oriented proposal. It is based on the principle that there's a governed visibility. Governed visibility simply doesn't mean that some knowledge is being hid from the researcher. It does not follow too extreme that the knowledge is not accessible to anyone or the knowledge is accessible to everyone. It does not follow any of the two extremes. Rather, it asks one simple question, as in who can access the knowledge and for what purposes and through what process under and what conditions as well. And with that, return to the knowledge holders. Under this model, communities are not treated merely as a source of information but as a stakeholders. Access can be differentiated according to treated in the same manner. Every record should also carry the metadata, including its resources, consent conditions, from where it traveled, and the benefit sharing obligations. A proposal is a meaningful only if it can be implemented. Therefore, the final part of the paper outlines a practical roadmap for India and the wider South Asia regions. The next
Participant,
question.
kindly conclude. Kindly conclude.
Yes, sir. The paper marks three central arguments. The first is digital biopiracy is a source to model governance problem. Second, the patent disclosure is necessary but too late on its own. Thirdly, the TKDL 2.0 can protect indigenous rights while preserving ethical open sciences. The first one says that biopiracy it has not disappeared. It has only evolved. In the digital age, extraction can occur through any stage, through any platform and through AI systems in the modern time, through physical movements also. So the second problem is that patent disclosure is necessary but too late on its own. It says that while existing the legal frameworks, they are adequate, but they are not highly relevant. They do not fully answer the question of AI in the modern time. Then ultimately, the objective is not to restrict someone for innovation. It is not anti science. Rather, it is to ensure that innovation remains accountable to the communities only, whose knowledge and stewardship should make it possible. Lastly, I would also like to mention that digital law make innovation accountable, not only make old forms of extraction harder to see. Thank you.
Okay. All right, participants, I don't have any question for you, but you should look into two aspects. Like, that's my recommendation. First aspect, when you talked about the TKDL is made for the purpose of public viewership, so that it can establish a platform where everyone can just go and look into what are the traditional knowledge India is having. That was only the purpose of TKDL. And like when you talked about the TKDL 2.0 model which you has suggested, those models are basically will be taken up into consideration upon the condition when a TKDL is having some lacuna or it is not performing as permitted. So in order to cater those, you have to come up with a more consolidated research for your paper.
Yes, I'll certainly look into that.
Okay, thank you for your presentation. Now we'd be looking, we'd be calling back Dr. Sumanta Bhattacharya again. Yes.
Yes, sir.
Yes, you can start with your presentation, Dr. Bhattacharya. Will it take time?
No, sir, I am already ready, but there is no skin sharing option, sir.
Okay, I think you are joined from mobile. I
Yes,
don't know
yes,
whether
yes.
it is having a screen sharing option for the mobile devices. Okay, you can start with your presentation. What you can do,
Okay,
you can just give your slides to the secretariat. You can send it via mail. We'll be
okay,
looking ahead to that. Yes.
okay.
Dr. Bhattacharya, you are not audible and visible. You are stuck. No, we can't take him. It's having technical issue. Yes,
Already
we
sent,
have to
sir.
move ahead. You are completely stuck. You are having a
No,
technical issue.
sir. No, no, sir. I sent the total PPT to Jasper, one of the admin of our group. And meanwhile,
Okay, you can.
if you
You
allow me,
can.
then
You
I
can
can.
start. Yes, you can
Okay,
start.
thank you.
We had already delayed. Yes, you can start. I would be
Thank you.
looking forward.
Good evening, everyone, distinguished dignitaries, respected professors and policymakers, and scholars and dear friends. Today, I stand before you not merely to speak about the technology, but to speak about freedom, trust, democracy, and the future of humanity itself. Today, my topic is digital authorization, internet fragmentation, and cross-border data governance, policy framework for cooperative cyber diplomacy and democratic digital security in South Asia. It is not just an academic subject, it is a defining challenge of 21st century. We are living in an era where data has become power, algorithms influence public opinion, and cyberspace has emerged as the new geopolitical battlefield. Every second, billions of people click, search, communicate, and share online. But the real question before us is, who control the digital universe? Is technology empowering humanity, or is it silently monitoring humanity? Across the world, we are witnessing the rise of digital authorization, where surveillance is becoming stronger than liberty, where algorithms can manipulate emotions, influence elections, and shape public perceptions. Go to the introduction page. Thank you. Okay. Now, next page. Now, whenever we are talking about the understanding digital authoritarianism, now the implication for the privacy freedom all are there. At the same time, across the world, we are witnessing the rise of the digital authoritarianism. Now, at the same time, the internet, once imagined as a borderless bridge connecting civilization, is slowly becoming fragmented. Nations are building digital walls, restricting platforms, controlling data flows, and creating separate cyber realities. Next page, please. Internet fragmentation in South Asia is a bigger challenge. I mentioned the points over there. Like in this point, if the fragmentation continues unchecked, and the greatest victim will not simply be technology, the greatest victim will be the trust between nations, trust between governments and citizens, and ultimately trust in a democracy itself. But, honorable members, history teaches something powerful. Every crisis also creates opportunity. Next slide, please. Now, the cross-border data governance and challenges are there, like the regulatory frameworks, secure data sharing. All I mentioned that the privacy protection gaps also there, and in this privacy protection gap arena, India introduced a DPDP Act. Next slide, please. Now, the cybersecurity threat linkages. I mentioned over there whatever the issues are there on a bullet point wise. Now, in the Southeast Asia and South Asia, home to nearly one-fourth of humanity, has the potential to become not a battlefield of cyber conflict, but a global model of cooperative cyber diplomacy. Today, the world is already searching for the balanced framework. Next slide, please. Now, the cyber diplomacy as a regional solution, as in the early participant, honorable members and honorable judges also mentioned that what are the European Union does for there. In my view, the European Union through its GDPR framework and the human-centric judicial governance model has strongly recommended that the technology must operate within the principle of human rights, transparency, accountability, and democratic values. The UE's message to the world is clear: digital advancement without ethical responsibility can threaten democracy itself. Next slide, please. Here I mentioned the policy frameworks. Now the vision is deeply relevant for the South Asia. At the same time, the government of India has emerged as a significant global voice in shaping responsible and democratic digital governance under the leadership of our Honorable Prime Minister Narendra Damodar Das Modi through initiatives such as the Digital India Mission, Bhasha App, Indian AI Framework, the Digital Personal Data Protection Act, Cybersecurity Cooperation
Participant,
Mechanism, and India's.
move to the recommendations. Move to
Yes,
recommendations
thank
and
you.
conclusion.
And next slide, please. Yeah, here the strategic recommendation: develop a South Asian regional cyber governance framework, harmonize the data protection and privacy regulation, create cross-border cybercrime investigation mechanism, and strengthening the public-private partnership in cybersecurity. Next slide, please. Now, before the conclusion, India's approach sends a powerful message. Security must not destroy privacy, innovation must not weaken liberty, and sovereignty must not prevent international cooperation. My colleagues and my honorable members and judges, cybersecurity today is no longer only but protecting cybers and networks. It is about protecting societies and protecting institutions, protecting human dignity. Artificial intelligence can predict behavior. Big data can influence decision making. Cyber tool can disrupt economics and national infrastructure. But no algorithm, no machine, and no state power should ever replace human conscience. Because democracy is not merely about elections. Democracy is about preserving human voice. Next slide, please. And therefore, in the digital century, protecting digital freedom is not only the technological responsibility, it is a moral responsibility. In the next generation will not ask us how fast our internet was. They will ask us, did you protect freedom in the digital age? Did you defend truth against manipulation? Did you build bridges between nations or invincible wall of fear? And our answer must be clear. We need ethical cyber diplomacy. We need transparent cross-border data governance. We need regional cooperation rooted in democratic values and collective century and mutual trust. Now, because in the 21st century, cyber peace
All
is
right,
national mission.
participant, you had exceeded time. So
Thank you.
there are one suggestions for your research to be looked into. There are reports from the United Nations Internet Governance Forum where they had suggested some of the frameworks for the South Asian countries, also for the countries who are least developed to the developing nations. So
Okay, sir.
I'll suggest you to look into those committee reports, also the secretariat report, like in order to understand how the internet governance framework is going up. Like we are not looking forward some strict governance like China, but also we are not looking forward to the loose mandate governance like the African countries. So we need certain in between. So that's what I'd be asking you to look into something into the United Nations Internet Governance Forum's portal and to their research reports. Thank you for your presentation.
Sure, sir. Sure. Thank you.
Now we'll be moving ahead with the next participant, Ms. Roshmi Paul.
Sir, kindly add my co-participant as he will be coordinating with the screen.
Okay, what's your co-participant name?
Anubhav Sen.
Okay, okay, Anubhav. Yes. Yes.
Uh, Good evening, respected chair. Now, before we start with our presentation, that is transitional justice and sexual and conflict-related sexual violence, I would like to ask a question. That is, when we often hear about the word genocide, what is the first instance that comes to our mind? Is it the one who got killed in that genocide or the one who got survived in that genocide? Now, I would like to quote the exact thing that has been quoted by a state practice. That is, my children are stateless. We are invisible to the law. For most of us, what citizenship is just a mere document. But for a genocide survivor, it is not merely a document. It determines whether a child or a person will be protected, recognized, or even forgotten in the future or not. And that is what the paradox of our research lies. How can a genocide that is globally recognized yet remain structurally unresolved? The 2014 Shinjar crisis has experienced this kind of thing. The clear red things are not just data, these are the things which the genocide victims have actually faced. 5,000 people were killed, women and children were abducted and were violently displaced following collapse of protected citizens. And this was not merely the consequences of the war, it was systematic, strategic, and it was also done to destroy the entire community. The Yazidi genocide has been documented by various international organizations, academic forums, and also across various legal data. Yet, recognition does not have guaranteed them the rebuilt lives which they actually wanted. The problem here was not invisibility, it was recognition without recovery. And this has led us to ask a question, which is like the concept of panoptic governance, which our paper suggests that post-conflict system often document, they recognize, categorize, monitor, and regulate in the name of protection. Yet visibility is something which necessarily does not produce the security. And this is not the condition of Yazidi genocide. This is also the condition which we have also seen during the time of Bosnia crisis, Rohingya, Rwanda, and even in Gaza as well, where international community often succeeds in documenting suffering, and yet they struggles to succeed in long-term recovery thing. Where we have also seen challenges like accountability mechanisms, reparations, insecurity limitations, institutional reforms as well, and the statelessness which continues to shape the lives of various people and the children across the violent means as well. Therefore, justice is something which should not move accordingly. It should move with dignity, autonomy, as well as it should restore the humanity. And one final reflection before I switch to my second author is the success of justice should not be measured by how many reports we publish or how many resolutions we adopt at the end of the day. It should be measured like how the survivors are able to rebuild their lives after violence. Because what we have seen is that taste of justice, it's not something which should be survivors are remembered. It should be restored so that long-term protection is given to the victims of this kind of genocide or violence as well. Thank you.
So, sir, the next parts will be covered by me. So, am I audible, sir?
Yes, you are audible. Go ahead.
Okay, sir. So, sir, as my fellow participant had said, that is panoptic governance. What does panoptic governance mean? And our paper is basically about the tension between panoptic governance and good governance in the post-conflict experience of the Yazidi survivors. Now, we need to understand what is panoptic governance. Panoptic governance refers to a system of control, surveillance, bureaucratic inspections that the survivors have to navigate through in order to access justice, reparative frameworks, and even the bare minimum necessities that they need in order to continue with their livelihood. Although we know that there have been reparative justice frameworks undertaken past in 2021, for instance, the Yazidi Female Survivors Law, but its implementation has been severely affected owing to civil documentation barriers, excessive evidentiary requirements. Even today, the children whose mothers have been victims of conflict related sexual violence during the ISIS genocide are at the risk of being stateless and having a stigmatized nationality. On the contrary, good governance
Okay,
restores dignity.
participant, you can move to the recommendations and conclusion.
Okay, sir. Okay, sir. So these are the major findings of our study. Okay, sir. So the recommendation. Our study proposes a three-tiered approach with regard to transformative protection. At the international level, it is essential to establish a hybrid international Iraqi tribunal, because we have seen that over a period of 12 years across five different European nations, there has been only 14 universal jurisdiction trials with regard to accountability for the Yazidi survivors, which reflects a major flaw for the Iraqi national courts as well as the international justice mechanisms. At the national level, we would suggest reforms to address the excessive evidentiary burdens faced by the Yazidi survivors, the civil documentation dilemmas they have to face, especially the children whose mothers have been victims of the sexual assault and rape by the ISIS genocide terrorist gang. And the next, we would say the civil society organizations like the Yazda, Nadia Murad, a founder of the Nadia Initiative, who was also a Yazidi survivor, to develop centralized and trauma-informed survivor-centered rehabilitation, which could be strengthened through psychosocial mechanisms, interventions such as the cognitive behavioral therapy, the narrative exposure therapy, to name a few. To conclude, we would say that the justice for the Yazidi survivors has to move beyond mere symbolic recognition of the sufferings they had to go through, but we need to recognize the enduring and the haunting realities of social exclusion, displacement, stigma they had to face, the collective intergenerational trauma led by years of genocide, not only on the present generation but also on the upcoming generations. They need to be understood as active agents of peace, not just victims of atrocities or other crimes. They are actively involved in creating a community which wants to come out of that haunting stories, haunting past experiences of that heinous crimes. Finally, we would say a meaningful justice mechanisms which require accountability on the part of the perpetrators, and the international criminal courts as well as the Iraqi national courts will have to
Participant, you are
establish
second
some kind
time.
of mechanisms in order to address that. Yes, sir.
Okay. So, like, there are two suggestions I will provide you for your paper in concern. First suggestion is like, see, when we can come up with this system of intolerance, or also like the whole media is neglecting,
Yes,
it
sir.
is a failure of digital rights. It's a failure of complete
Yes, sir.
digital governance where there is no media outlet is covering. So you have to
Yes.
connect this complete matter. Like nowadays, we are living in the 21st century, which is known for the lifeline of digital rights. Like the whole lifeline of 21st century is digital rights, where we are
Yes.
having the digital voice. There, these things will never happen. So how we can cater up your policy recommendations should be such framed, like where you can come up with such kind of solutions where a digital right can be boosted up. After boosting a digital right, this type of issue would be resolved, where a media highlight or the media mandate will be possibly overseen by the global people at such, and every global gateway would be connected to these nations. So your recommendations should connect to those. I will ask you guys to look into these aspects.
Okay, sir.
All right.
Sure,
Thank
sir.
you.
Thank you, sir.
Yeah. Now we are moving ahead with the next participant, Devashish Lahiri. Okay. Participant, you are not visible and audible.
Hi, am I audible?
Yes, you are audible, but you are not visible.
Do I need to come on camera? Is it a
Yes, it is mandate for the
necessary?
presentation. Okay. You can
Hi,
start with your presentation.
yeah. So my topic is intellectual property rights and AI knowledge diffusion. So basically, what we have tried to do in this context is try to find out how AI knowledge is being diffused throughout the world today. We have majorly talked about the WTO system, the TRIPS agreement system, and the WIPO system. Uh, the slide not moving. Just a moment, the slide is not moving.
You can simply just scroll down and present. Your entire screen is not shared, that's why it's the issue. You can simply just scroll down and present.
Am I audible? Yes, you are.
Yes, you are perfectly audible, but your screen like is not moving ahead.
No, I think some third person is speaking. That is not my voice. Should I share again? Should I stop sharing and share again?
No, you can. Okay, you can reshare it, but don't take time. We had already delayed it. Mr. Lahiri, your screen, kindly share it. Okay,
Can you see
yes, your
now?
screen. Yes, your screen is visible, but your slides are not.
Yeah, I think there's some technical difficulty. If I'm switching on my video mode, then I'm not able to scroll. So I'll go ahead with my presentation then, right?
Yes, you can go ahead.
So on screen, you can see why this matters. We have taken the WTO report of 2025. That's the annual report of
Participant,
World
your
Trade Organization.
screen is not visible. Like it's showing the StreamYard screen. Your slides are not visible in the screen.
Why is that? I can see. Just a moment.
You have to give entire permission to the entire screen.
I have already given. My entire screen is there. Just I don't know. It was showing a moment ago.
Okay, you can do one thing. You can just start your presentation and you can share your presentation later on to the secretariat. We'll look into it if it is having a technical issue.
Wait, give me 1 second. 1 second. Can you see now?
Yes, I can
Is
see
my
now. You can see, yeah, you can scroll down and you can present. Yeah.
yeah. So yeah. So as you can see on the screen that we have tried to take the WTO report of 2025 that gives a growth annual growth of AI patent citations to 2.6%. Now, why we have taken the metric of patent citations is cross-border patent citations is because between countries, if there are cross-border patent citations, that shows that the level of development and level of trust that both countries have in each other's patent system and enforcement systems. Now, secondly, we have analyzed the TRIPS agreement as a gatekeeper because basically TRIPS agreement, when it was drafted in 1995, 1996, it was drafted in a technology neutral language. So AI, we cannot say that AI is not included in the language, but way the TRIPS system has been interpreted the world over, we cannot say that patent system actually integrates the AI part in it. Third, we want to show that global trade flows can be influenced and actually participate in AI knowledge diffusion so that even third world countries or the global south can benefit from the AI developments that are taking place in the first world. Now we can come to the research question and research gap. How do multilateral IP regimes shape AI knowledge flows through international trade? The IP regime, that is the TRIPS agreement, as we know, and international trade helps in as the trust between two countries having similar or homogeneous IP regimes develop. The trade flows also develop through that. The TRIPS agreement was one of the major aims of the TRIPS agreement was having a basic standard of IP protection throughout the world, so that this trust can be built, and this IP flows and IP regimes can be homogeneous, and technology could be transferred. This transfers to the AI regime also, though the TRIPS agreement does not specifically talk about the AI system. Now, the methodology that we have used to prove this is the PATSAT AI patents data that is only available till 2022. This has been taken by the WTO trade report also, and it is available on the EU IPO website. The model that we have, economic model that we have used is the gravitational model and the PPML estimator model, the Poisson model. Basically, PPML means Poisson model. The analysis that has been done is the patent citations have been correlated to the basic TRIPS doctrine. Now, what we have found that there is 15 to 20% increase in patent citations from strengthened IP enforcement, wherever the IP enforcement is as per the basics of TRIPS or TRIPS plus. The patent citations between the countries are more, the technology flow between the countries is more, and similarly, the AI diffusion between the countries is more. In countries where, specifically for LDCs, where the patent citation, the TRIPS standard is not maintained, or it is TRIPS minus, they are still reaching the TRIPS standard. The technology transfer is not that much because the trust in the enforcement system has not developed to that state.
Participant, you can move to the recommendation portion.
So what we have recommended is basically in three pillars. First, we need to clarify the AI IP system through a WTO WIPO cooperation. One of my friends just mentioned the GRTK treaty that the WIPO is trying to get every country to sign. So we recommend a similar system that can be developed for the AI. Second, enable AI data access as is there in EU through EU directives, but that is only through for the EU countries. We would recommend a similar system through the WTO system or the WIPO system to be implemented worldwide. And thirdly, the equitable, we have connected it to the special and differential treatment for the LDCs and the SDG 9, that is innovation, and SDG 10 goals that have been developed for the entire world. So AI should be diffused through the entire world for use in health, for development, engineering, etc. Now, what is the final balancing incentives and access? This is the basic crux of the paper and the presentation, that innovations, strong IP rights are required, strengthening IP rights are required, but now is the time to build in certain flexibilities into the AI, because of AI, into the present IP regime, that is the WTO TRIPS agreement and the WIPO regime, so that technology transfer is easier and more accessible worldwide. Thank you.
Okay, thank you, participant. There is no question for you. Thank you.
Thank you.
Okay, now we'll be moving ahead with the next participant, Khubi Agarwal. Okay, yes, participant, you can share your presentation.
Yes, sir. Is my
Yes, you can.
screen visible? Yeah.
Yes, it's visible. You can start.
Good evening, respected Chair. I am Khubi Agarwal and I will be presenting my paper, Securing the Digital Space, Public Space, Cybersecurity, Platform Power and Rights-Based Governance in South Asia. At the onset, I would like to begin with a simple proposition. The greatest threat to democracy in the digital age is not merely the cybercrime, it is the concentration of power over digital spaces without adequate accountability. Today, more than 1.9 billion people in South Asia rely on the digital platforms for political participation, economic activities, social interaction, education, and so on. Yet, the digital public spheres is increasingly governed by two powerful actors, states exercising surveillance and control in the name of innovation and profit. This creates a fundamental question: who governs the digital public sphere? And more importantly, who protects the rights of those who inhabit it? The question forms the core research problem of the paper. The paper's findings reveal a common pattern across South Asian countries. The cybersecurity governance remains overwhelmingly state concerned. In India, despite the landmark case decision in Shreya Singhal, where the striking down of Section 66A happened, and the regulatory approaches continue to prioritize surveillance and excessive control. Similarly, across all the states of South Asia, demonstrates the growing tendency to expand executive control over digital expression. The result is what we describe as an architecture of insecurity. Ironically, laws enacted in the name of security often undermine the very rights they claim to protect. Secondly, a second dimension of the crisis concerns internet shutdown and the surveillance technologies. India alone accounted for a significant proportion of global internet shutdowns in recent years. Although the Supreme Court in Anuradha Basin recognized the constitutional significance of internet access, digital connectivity, which still lacks in adequate legal protection. This creates a dangerous imbalance between the technological capacities and the constitutional accountability. However, states are only one side of the problem. The second actor is the digital platforms. Platforms such as Meta, Google, X have become the private governors of the public discourse. Their algorithms determine what information citizens encounter, what voices are amplified, and what narratives demonstrates the public debate. Yet these decisions remain largely opaque. The paper argues that this phenomena constitutes a form of platform authoritativeness where private corporations exercise regulatory power without the democratic legislation or constitutional constraints. The challenge, therefore, is not simply cybersecurity, it is governance. And this leads to the central contribution of my paper. We propose that we call a rights first security architecture, or the FRCA. It rejects the false choice between security and liberty. Instead, it argues that the cybersecurity should be designed around protecting rights rather than restricting them. The framework rests on five fundamental principles. Firstly, the privacy of individual rights, ensuring that privacy, free expression, and equality remain the starting point of governance. Secondly, the democratic accountability, requiring meaningful judicial oversight, particularly in the parliamentary scrutiny and algorithmic transparency. Thirdly, multi stakeholder governance that involves civil societies, academia, technical experts, and affected communities in regulatory decision making. Fourth, the structural proposition, meaning privacy by design, encryption, and data minimalization, should be built into systems from the outset rather than added as an afterthought. Lastly, digital equity, recognizing that access to secure and affordable internet is a prerequisite for meaningful participation in modern democratic life. Building upon these three principles, the paper advances several institutional reforms that ultimately creates a regional South Asian digital governance platform or framework capable of addressing cross-border digital challenges. To conclude, the crisis of cybersecurity governance in South Asia is fundamentally a crisis of constitutional governance. The question before us is not whether digital technology should be regulated. The real question is whether the regulation will serve power or protect the rights. As governments acquire unprecedented surveillance capacities and platforms gain unprecedented influence over public discourse, the future of democracy be increasingly determined in the digital spaces. Securing the digital public sphere, therefore, is not merely a technical project. It is a constitutional imperative, it is a democratic necessity, and it is one of the defining governance challenge of our generation. Thank you.
Okay, participant, I'll suggest you to look into the OECD guidelines and the OECD recommendations, policies, whatever it has been made for the digital governance, also the cyber security, in order to come with a very brief manner and your paper to have a very refined and policy recommendations.
Sure, sir. Thank you. I'll definitely look into that.
Okay, all right. Thank you for your
Thank
presentation. Now we'll be moving ahead with Miss Shraddha Sheth. You are not audible.
Am I audible?
Yes, you are audible now. You can start with your presentation.
Yes. Uh, good evening to the respected chair. Today I'll be presenting a critical paper on, as it shows on the screen, the digital self, biometric unlocking, informational autonomy, and the Indian constitutional right against self-incrimination. Now, this paper addresses a fundamental question that sits at the intersection of technology, law, and human rights. Particularly when police force someone to unlock their smartphone using their fingerprint or facial recognition, does that violate their constitutional right against self incrimination? And more broadly, how should we understand our smartphones in constitutional terms? So, let me first articulate the critical research problem that has been addressed in this paper. That is, the constitutional challenge addressed in this paper is not merely whether state may access a suspect's smartphone or any electronic device during investigation, but whether constitutional doctrine has kept pace with the transformation of personal identity in the digital age. So the issue emerges at the intersection of Article 20, Clause 3, protection against self-incrimination, Article 21 that guarantees privacy, an increasingly significant role of digital devices as repositories of personal identity. Indian courts continue to confront digital searches through conceptual framework developed for an analog world. When investigating agencies seek access to encrypted devices through fingerprints or facial recognition or iris scans or passcodes, courts frequently rely on precedents concerning fingerprints and other physical identifiers without recognizing the radically different constitutional interests implicated by modern smartphones. So the problem becomes evident in judicial reasoning that attempts to justify compelled unlocking of electronic devices through provisions of Code of Criminal Procedure. I'm aware that now Bharatiya Nagarik Suraksha Sanhita has been newly adopted, but howsoever the cases that I have dealt in this paper are dealing with the Code of Criminal Procedure, which is why I'll be looking into the sections therein provided as per the court's analysis in the judgments. So the courts have suggested that a password, passcode, or biometric identifier may be treated as a document under Section 91 of CRPC, and that search warrants issued under Section 93 CRPC may extend to smartphones and laptops or any electronic devices. Further, by invoking Section 100 CRPC, courts have reasoned that an individual may be compelled to cooperate with the investigators by providing access credentials or unlocking the device. This approach raises serious constitutional and statutory concerns. First, a passcode or a password is fundamentally different from a document contemplated under Section 91 CRPC. Unlike a pre-existing physical document, a passcode or a password or any thing for that reason ordinarily exists only within the individual's mind and constitutes personal knowledge. Its compelled disclosure therefore raises questions under Article 20, Clause 3, which protects an accused from being compelled to furnish testimonial evidence against oneself. So, by treating a password or a passcode or a biometrics as an ordinary document, courts risk collapsing the distinction between physical evidence and testimonial communication that lies at the heart of self-incrimination jurisprudence. Secondly, the statutory basis for treating smartphones as searchable places under Section 93 CRPC, it remains questionable. The provision authorizes searches of places, while Section 2, Clause P, defines places to include houses, buildings, or anything. Applying the principle of agestem generis, electronic devices do not naturally fall within the category. So, most importantly, these judicial approaches fail to recognize the constitutional significance of smartphones themselves. A smartphone nowadays, it is not merely a container of evidence analogous to a logged cupboard or a physical file. It contains communications, photographs, location histories, financial transaction, health records, and other form of deeply personal information. So it functions as an extension of individual identity and autonomy. So consequently, compelling access to a smartphone cannot be equated with obtaining a fingerprint for identification purposes. So the central problem therefore lies is that whether existing Indian constitutional doctrine adequately protects individuals when the state seeks compelled access to the digital devices. So it asks whether Indian courts have failed to appreciate that in the digital age, biometric unlocking is not merely the production of a bodily characteristic, but may also operate as a compelled disclosure of identification purposes. So, so I think it's now clear that why this problem matters, as because the constitutional stakes are enormous here. So we are
Participant,
not
you
just.
can move to the recommendation and suggestions portion.
Yeah, sure. I'll just go to the page. For time being, the paper's solution is that the answer is that the concept of digital personhood as an emerging constitutional principle. So the paper argues that resolving this crisis, it requires recognizing digital personhood as an emerging constitutional principle. Understanding smartphones or any electronic devices not as mere evidence but as repositories of digital autonomy, informational control, and constitutional identity itself. So the key insight is this, that smartphones, they are not merely evidentiary containers, right? So they are the repositories of in many personal data. So compelled actions therefore implicates not merely evidentiary concerns but informational autonomy and protection of the digital self. So the paper argues that existing constitutional doctrine must evolve to address the transformation, and judicial doctrine must move beyond purely mechanical distinction between testimonial and physical evidence, and instead focus on the constitutional implication of compelled access to the personal digital information. Thanks.
Okay, thank you, participant. I don't have any question for you. Thank you. So now moving ahead with the last participant, we have Kumari Nisha and KVS Sai Pradyumna. Yes, participant, you are not audible and visible.
Hello.
Yes, you are visible and audible. You can start.
Yeah. Good evening to everyone. I am Kumari Misha, and today I'm going to present my paper on the topic Algorithmic Governance, Digital Rights in South Asia. So, we have chosen Bangladesh and India to study this topic as AI is one of the fastest mode which is growing all over the country. And South Asia is home to roughly 1/4 of the world's population, and it has become critically testing ground for AI governance system. Governments are continuously deploying different tools like facial recognition, biometric database, predictive policing, and digital monitoring at a massive scale. While these tools promises efficiency and security, they are expanding faster than the legal frameworks meant to govern them. So our research focuses primarily on India and Bangladesh. Moving to the next slide. So the research objective, we have five core research objectives. Um, our study has like to decode where AI surveillance system examining their constitutional implications, evaluating data protection frameworks, identifying risk of digital authoritarianism, and proposing a governance solution. The kind of methodology we use to study this is that doctrinal and comparative legal analysis, drawing on
Okay,
constitutional previous.
participant, you can skip the methodologies.
Oh, okay. Coming to the main core problem of the paper. So in India, the Aadhaar system is the world's largest biometric ID and has enrolled around 1 billion people, linking to the different identities like banking, healthcare, and other welfare delivery systems. While the Supreme Court landmark Kuppaswamy judgment of 2017 declared privacy is a fundamental right and demand proportionality in surveillance, the reality on the ground it still differs. Facial recognition is now embedded in the smart city infrastructures and used by the law enforcement for predictive policing. And despite the Digital Personal Data Protection Act of 2023, there's still no comprehensive regulatory framework for algorithmic accountability and automated decision making. Similarly, in context of Bangladesh, um, the Digital Security Act of 2018, which has been widely criticized for enabling arbitrary surveillance of journalists, activists, and political opponents under the guise of national security. There is no meaningful data protection law, no independent oversight body, and biometric systems are being integrated into law enforcement without adequate transparency, which results in disfragmenting the marginalized community from the main idea of the law system. Moving to the next slide. Yeah. Across both the countries, AI surveillance creates a chilling effect on democratic participation. When people know or even suspect they are being watched, they are self censored. Algorithmic systems are often opaque, no meaningful right to appeal, and critically, these systems encoded existing biases, meaning minority communities, women, and the poor face disproportionate surveillance. Constitutional protection designed for analog world are simply not equipped for the scale of automated governance. Cybersecurity and digital authoritarianism. What begins the concept of cybersecurity justification gradually becomes the permanent infrastructure for political control. We see this pattern globally, tools built for emergencies, but still can't get switched off and can be used again and again for this purpose. International frameworks like GDPR, OECD, AI Principle, and UNESCO's AI ethics recommendations offer a strong normative foundation. The EU has gone so far to restrict facial recognition in public spaces. South Asia can and must draw from this model and like
Participant, you
not
can move
copy.
to the solutions and recommendation.
Okay, fine. Thank you, sir. Yeah. Hmm. So we have proposed a right-based AI governance framework for South Asia. So our central contribution is right-based governance framework for South Asia, built on 6 pillars. First, to have a comprehensive data protection legislation with informed consent and data minimization. Second, algorithmic transparency. Citizens must know how the decision about them are being made. Third, independent oversight with genuine judicial and parliamentary authority. Fourth, mandatory human rights impact assessment before AI deployment. Fifth, algorithmic accountability with real appeals mechanism. And the last is regional cooperation because surveillance systems and data flow do not respect national boundaries. I would like to conclude. So AI has enormous potential to strengthen governance system, but right now the trajectory is so dangerous. Weak legal safeguards, and absence of oversight and depending digital authoritarianism in both India and Bangladesh demands an urgent reform. And our argument is simple: technology must serve democratic institutions, and common citizens must know about the tools and how their data can be used further. So human oversight is still the central part of AI governance system. Thanks. I'm open to the question now.
Okay, have you mentioned or cited India's AI policy report which Niti Aayog has published last year?
No, sir.
Okay, try to look into this aspect. You will be getting number of points. What's India and what's the South Asia thinking for the artificial intelligence enabled, and which direction AI governance is going to be. So that is one of the report which your topics needs to have. So thank you. That's only the thing. I'm not having any question for you. Thank you for your presentation.
Thank you so much, sir.
Okay, with this, we had come to the concluding part of this program. So, participants, with immense gratitude and satisfaction, we formally conclude the second South Asian Symposium on Cybersecurity and Digital Rights 2026. May this discussion, initiated today, continue to inspire research, policy innovation, and international cooperation towards building secure, inclusive, democratic, and rights-based digital future. Thank you for participations and stay safe, stay connected. We look forward to welcome you again in future in number of international conferences and symposium which would be hosting in the third edition of South Asian Global IP Summit. Have a wonderful day ahead. Jai Hind and thank you. Thank you everyone.